Well, I hear the room getting quiet, so it's time to start. I appreciate that. I'm Robin Wilson. I'm the Law Review Advisor. I'm not going to say much other than to introduce our introducer and the person who will welcome you, who is Hal Clark. He is on our Law Council, for which we are very grateful. He's both an undergraduate 1973 grad as well as a law grad, so he did the double plan. He's the Senior Vice President and Deputy General Counsel for Wells Fargo Advisors, where he leads the legal teams for retail brokerage and asset management. And in addition, he represents, this is fascinating, the estate that oversees the intellectual property for Gone with the Wind. And as I said, he is representing our Law Council and here to welcome you today. Thank you.
Thank you very much. I appreciate that. Let me welcome each of you to the 2010 Law Review and Law Council Student Notes Colloquium. Each year, the Debbie Law Review and Council sponsor this program to highlight student notes which demonstrate excellence in legal research, analysis, and writing. Today's program has two such notes. The first is entitled Independent Contractors, Employees, and Entrepreneurialism under the National Labor Relations Act, a worker-by-worker approach. It was written by Micah Jost, a member of the class of 2011. Dean Grunwald will introduce this segment, after which Mr. Jost will present his notes. Professors Hirsch and Millen will then comment on the note. The second note, SIGTARP and the Executive Legislative Clash, confronting a Bowser issue with an eye towards preserving the separation of powers during future crisis legislation, was written by Aaron Sims, who is also a member of the class of 2011. Professor Murchison will introduce this segment of the program. After Mr. Sims presents his notes, Professors Siegels and Scales will comment. At the conclusion of the program, our speakers will be down front with the professors, and I hope you will come down and congratulate them. But I ask you to join me in congratulating both the gentlemen now on their notes being selected. Now it is my pleasure to introduce Dean Grunwald to begin today's program. Thank you very much.
There's a lot of pleasure to be expressed today on behalf of the note writers and the law school and the families of the note writers here. I'm going to introduce Micah and Micah's note. His family is here, his dad, Tim Jost, his mother, Ruth Stolfus, his brother, Jacob, and cousin, is that right? Cousin Josh Fair. You have any other family here? Okay. Welcome. It's great to have you here. Let me tell you a little bit about Micah's background, and then I'll tell you about my experience with him, and I'll try to keep this brief so there's plenty of time for the interesting discussion that I think we'll have. Micah did his undergraduate work at Goshen College in Goshen, Indiana. He graduated from there summa cum laude. Between his graduation and law school, the 1 year between those two events, the beginning of law school, he worked for the United Steelworkers and got involved in a number of different ways in the labor movement in the United States. And he probably had an interest in labor relations and employee rights before that, but that certainly furthered that interest and in some ways led to his note. You know now he's a senior articles editor of Law Review, and you've all, most of you who are students here, have gotten to know him quite well around school. I advised the note, but I came to doing that in a different way than I usually do. I almost always end up advising a note of a student who was in my first year small writing section. That's a way to get to know students very closely, and that's often what leads to then the role of becoming a note advisor. In Micah's case, I did not have the good fortune to have him as a first-year student, but in the year that he was a second-year student, I didn't offer the course which I often offer, labor law. That's the regulation of labor relations. And I set up a tutorial with Micah to cover that subject area, that area of his interest. And we met on a weekly basis. I gave him reading assignments. He prepared a paper each week, and that we then talked about his paper. Even though I spent only an hour with him each week, it was close to being, if not the best hour of my week. It was a great time. I maybe helped him learn a little labor law. I learned a lot myself working with him. He always had fantastic questions that made me think more deeply about some things that I thought I was familiar with. It was a great experience. And in the course of that, he mentioned to me this note topic that he was thinking about. Now, as you know, the note concerns the employee independent contractor distinction. It's one that all of you have encountered, all of you who are involved in law have encountered in one form or another. It's a distinction that's been around for a very long time, caused lots of trouble for a long period of time. And Micah told me he'd read a D.C. Circuit opinion in which he thought they were doing something interesting that might lead to a note on employee independent contractor. And I thought to myself, oh no. I mean, this has been done, it's been done again and again and again, and there couldn't possibly be anything new here, and what a difficult way to start out. You know, being interested in the topic, but then discovering that it's been written and overwritten. Well, I didn't discourage him right away because he said he wanted to come back to me with some thoughts on it. And as he did, this happened in the course of a week or two, 3, I actually saw that he had something in mind that had the potential for being good. And I encouraged him mildly, although Micah doesn't need a lot of encouragement. He digs in himself. He turned it in, the idea, into a first draft, so I read it. And I was really amazed with what he had done. The topic, which was, I think, had some potential, as I said, potential to be a good note, turned into potential to be a great note. And in fact, that is how the note turned out. That's why we're here today. It was clearly one of the best notes that was published last year, and it's really one of the best student notes I've ever advised. What he did is he took, and commenters and Micah himself will address this obviously in more detail, but he took a D.C. Circuit decision which dealt with this, fairly well-worn topic. And the court was moving in a direction which I don't think suited Micah's own disposition, and he found a way to turn what the court had said into an opening for moving in a direction which was preferable to him, and that's really, what the note accomplished. It's beautifully written. It creatively explores an area that, requires a lot of creativity to justify further treatment, and I found it an exciting educational experience, and I'm glad to be here today to introduce Micah, and I think we're all fortunate to have Micah as one of our students and colleagues, and this note is a very nice contribution to the world of legal scholarship. So, Micah.
Good afternoon. Thank you all for coming out today, and thank you, Professor Greenwald, for that very generous and kind introduction. I'm honored to be speaking to all of you today about my note, and I'm grateful to Professor Miller for coming out to comment on it today, and in particular, I want to thank Professor Hirsch for coming all the way here, driving all the way here from the University of Tennessee today. I'm honored to have you here. My presentation this afternoon is about the law governing workers' rights. Specifically, it's about the rights of people who work outside the mainstream employer-employee relationship. If any of you have been paying close attention to the legal job market these days, you may be particularly interested to find out what kind of protections you'll have if you don't have an employer. You may be troubled to learn that the answer is you don't really have any protections at all. My note focuses on labor law, which is a fascinating but deeply flawed area of law in this country. The National Labor Relations Act turned 75 years old this year, and many people in the field believe that it's broken, that it no longer accomplishes the goal it was set out to achieve, which is to ensure that workers have the right to organize and collectively bargain with their employers. Most of the reasons for that are outside the scope of this talk. More specifically, my note is about a particularly flawed distinction within labor law, and that is the line separating the employee from the independent contractor under the National Labor Relations Act. I'm assuming that no one here in this classroom except for professors has taken a labor law course. Is that correct? In light of that, rather than trying to provide a broad introduction to labor law or a discussion of the history of the labor movement and where it is today, I'm going to try and keep things concrete and focus on specific examples. There are two companies that illustrate pretty well the points that I make in my note. Those companies are UPS and FedEx Ground. As some of you may know, UPS is a union company. It employs about 240,000 drivers across the country, and they are members of the International Brotherhood of Teamsters, which negotiates on their behalf for wages, hours, conditions of employment, pensions, etc. At the same time, FedEx is also the largest delivery company, which is 100% non-union in the ground delivery area. It's non-union in spite of the fact that groups of drivers in certain geographical areas have actually organized and voted for union representation in elections overseen by the National Labor Relations Board. The reason for that is that FedEx has consistently and usually successfully at the circuit court level, if not at the NLRB level, argued that those workers are not employees, they're independent contractors. And so, technically, under American labor law, anyone driving a truck for FedEx doesn't actually work as an employee of FedEx, they work as an independent contractor. The National Labor Relations Act was amended in 1947 to exclude independent contractors from its coverage, and so they cannot form a union. A lot of companies today rely on independent contractors or other contingent work arrangements, such as temp workers, leased workers, to get their work done. The issue has become especially prevalent in light of the recession, where a lot of employers feel themselves obliged to restructure their work arrangements to save the maximum amount of money. They tend to phrase these arrangements and their choices in terms of flexibility. They need to have a flexible workforce. But of course, what it comes down to is cost. When you are employing independent contractors to get your work done, you're essentially paying 20 to 30% less because you're not paying Social Security, you're not paying for unemployment benefits, you're not paying Medicaid. In addition, your employees or independent contractors are not protected by the Fair Labor Standards Act, which would give them minimum wage and overtime. They're not protected by ERISA. They don't have the Family Medical Leave Act or Title VII or the ADA or ADEA. There's a whole raft of laws that they don't have access to, also including state laws, which are in place to protect employees from having the cost of business shifted onto them by an unscrupulous employer. A lot of workers find themselves in this position. About a third of the workforce overall is classified as contingent workers, which again, temporary workers, leased workers, part-time workers, and independent contractors. And the estimates that I've seen of independent contractors out of the whole workforce range from around 7% to 12%. Those numbers are pretty old. It's probably significantly higher now. So in addition to losing these other protections that I mentioned, these workers don't have the right to join a union. And you may wonder why I focused on that specific right. And the reason is this. It's a pretty popular anti-union line these days to argue that unions are obsolete. The argument tends to go that unions fought for all these protections on the job, such as minimum wage, OSHA, etc. And now we have those things, and so unions have essentially put themselves out of business, is what the argument is. I think that's a flawed argument, ordinarily. But I think it's even more flawed when you look at independent contractors who don't have those protections and, in addition, do not have the right to organize and demand them from their employer. I think this is a fundamental injustice in the way that our economy is structured, and I think it may conform. At this point, I'd like to turn to the more technical side of the law. I'm going to stay mostly out of the case law because it's extremely fact-bound, and I don't think we would get very far talking about individual cases. Those of you who are in Professor Shaughnessy's legal writing class with me first year will recall exactly how fact-bound the independent contractor versus employee distinction can be. But the basic framework of the issue is this. You have a lot of statutes, as I described, to protect workers from discrimination and exploitation on the job. And these statutes only apply to employees. But they fail to actually define what an employee is. You'd think that it's something that's straightforward, and that's what the legislators tend to have thought when they wrote the statutes. So a typical definition might say an employee, for purposes of X statute, is any employee employed by an employer. You can see that that's not very helpful when you're looking at a person driving a truck for one company and a person driving a truck for another company. But even if most of you haven't taken labor law, you probably have taken close business arrangements with Professor Millen or some sort of torts class, perhaps with Professor Scales. And so you'll recall that there's some sort of restatement that discusses agency and discusses what an employee is and what an independent contractor is. And if you cast your mind back to the restatement second of agency, you'll recall that there's a multi-factor test. There's a whole list that goes down the line, putting out various things that are thought to distinguish the two and focusing fundamentally on the issue of control. The idea is that if an individual has the power, the right, to control the means and manner by which someone else does their work, that principle becomes the master and the agent becomes a servant. This makes sense at first, but there's a problem when you try to apply those definitions in the labor law context. The common law definitions emerged in the context of apportioning tort liability, based on the idea that a master who can determine how their servant does their work should be liable for the mistakes or the torts that the servant commits. The whole variety of labor protective statutes that were passed starting mostly around the New Deal era have nothing whatsoever to do with tort liability, except with the exception of workers' compensation statutes. Instead, they have everything to do with offering protections to workers who need those protections. The degree to which a worker is controlled by the employer in the means and manner of their employment tells you literally nothing about the degree to which that worker needs minimum wage, or needs to have a safe workplace, or needs to have the right to organize. There's another serious problem in addition. Control, which is at the core of the common law test, is an extremely malleable and easily manipulated concept. To use a few examples, does FedEx control the means and manner of your work if they tell you how short you have to cut your hair, what uniform you have to wear, which finger you put your keys on when you approach the door of a customer, and what logo you put on the side of your truck? Some courts have said no. They've said that's not control if it's mandated or sort of dictated by customer expectations. To use another silly example, if you have a group of specially trained kosher butchers who are working in a slaughterhouse, and they're working 9 to 5 on the factory floor with a foreman, but the foreman happens to be a Gentile who doesn't know anything about the technicalities of the religious regulations, can that person really be controlling the means and manner of their employment? Courts have said, in at least the D.C. Circuit has said, that in that case, there is no control over the means and manner, and those individuals are independent contractors. Now, FedEx obviously is not the only company that uses independent contractors to do work we traditionally think of as being done by employees. It often happens in areas of the economy where control can be easily attenuated, where people can do their work without a lot of direct supervision by management. This includes a whole wide variety of areas. You have home health care workers, taxi drivers, computer programmers, truckers, janitors, insurance salespeople, and farm workers. Often, the arrangement involves a few little tricks. You can have a janitor who's leasing a floor of an office building from the owner of the office building, and under that lease arrangement, there's no control over the means and manner of the person doing the cleaning, and so they are an independent contractor. You can also have a situation, as FedEx does, where drivers technically own their routes. So a driver owns the route which your house is on, and they can buy and sell that route. And that is supposed to change the fundamental nature of their employment. These arrangements can pass certain legal tests, but they seldom change the fact that you still have an employer who's providing capital, and you have a worker who's providing the labor that makes that capital productive. Businesses have, of course, become unbelievably creative about this, but even so, the basic strategies are not new. There's a case that I mentioned in the note from approximately 100 years ago, where Judge Learned Hand dealt with a situation where a coal company owner was trying to make all of the coal miners independent contractors. They would essentially lease out an area of the mine to the miner. You get to go in and do your work in this area that you have on lease. And if you hire any helpers, they work for you, they don't work for the coal company. Learned Hand basically set this aside he looked at the purpose of the workers' compensation statute that was at issue, and he said, who is this designed to protect? Is it designed to protect individuals who are working in a mine and get injured as a result of that work? Obviously it was. And so he set aside, he disregarded the form that the employer had created and focused on the substance. Unfortunately, the Supreme Court has said, first, that the common law applies in these statutes where Congress doesn't offer a helpful definition. And further, the courts and the National Labor Relations Board are not permitted to consider the statutory purpose, which governs the classification. And so that's why you have these absurd situations where a court is deciding who gets coverage under a statute designed to give people protection in light of inequalities of bargaining power. And the court is not allowed to actually ask whether the individuals at issue suffer from a lack of bargaining power. You also end up with situations like the kosher butchers, who are obviously just as deserving of labor law protections as the other workers who are doing their work 10 feet away. You, of course, then have to ignore the fact that independent contractors don't actually exist as a unified class of workers. It's a bimodal group. On the one end, you have people like farm workers who have few marketable skills outside of picking fruit. And on the other end, you have business consultants who are making six figures. But the court provides the same legal protections or lack of legal protections to both. In my case, that I focused on in my note, a bunch of FedEx drivers had gotten together and decided to unionize. They're in Massachusetts. They voted by a strong majority to be represented by the Teamsters. And FedEx argued, after they had won, that the drivers could not form a union because they were independent contractors. FedEx emphasized that the drivers had to buy or lease their own trucks. Trucks, of course, had to say FedEx on the side. And that the drivers could buy or sell their delivery routes. And they could hire helpers and subordinates to do the work. Drivers could also use their FedEx truck for any variety of business endeavors outside the FedEx context, on their off hours if they had any, as long as they covered up the FedEx logo. The National Labor Relations Board disagreed with this approach. They focused on indicators of control. They focused on FedEx requiring uniforms, requiring licensing of their drivers, and otherwise basically telling drivers how to do their job insofar as there's any variety of ways to deliver a package. In addition, the board actually did not focus on the individuals who owned multiple routes because under the National Labor Relations Act, supervisors, just like independent contractors, are not provided the protections. So the board wasn't focusing on the individuals that really drove the analysis on the FedEx side. Now, the Circuit Court of the District of Columbia sided with FedEx in this matter. They decided, instead of focusing on control, to make an interesting transition in the analysis. Instead, they decided to focus on entrepreneurial potential, or the potential inherent in a job for loss or gain based on the individual's entrepreneurial skill. The court thought there was enough of this present to tip the scales and make the drivers into independent contractors. Now, I say this is interesting for a couple of reasons. First, fundamentally, I think it shows the complete wrongness of the common law approach. You really can't say that entrepreneurial potential is a better indicator of independent contractor status if you're not allowed to talk about what it's better for. If you can't look at the purpose that the statute is meant to achieve, literally any of the restatement factors or any other number of factors could be the better way of determining what a real independent contractor is. The thing I want to emphasize is that there is no such thing as a real independent contractor or a real employee. They're legal fictions that the statutes use to accomplish a purpose. There's a good quote that I used to start off my note, and if you don't take anything else from this talk, I hope you'll remember it. The quote is, "We do not find out who or what an employee, legally speaking, is. It is open for us as a society to decide." Even though I think this fact should be painfully obvious, it's something that the courts often forget or feel they have to ignore. The other interesting thing, and what my proposal really comes down to, is that the D.C. court made it clear that it was the potential for entrepreneurialism, not the actual exercise of entrepreneurial activities, that drove their analysis. Only a few of the drivers at issue actually owned multiple routes or used their trucks for other endeavors on the side. But the court said those opportunities are open to everyone, and therefore the status of the entire group can be changed. I don't think it has to be that way. When you talk about control, going back to the common law, if you think back to close business arrangements and torts, you'll remember that it's a question of the right of control, not the actual exercise of control. If you have 30 drivers who are working under the same contract in the same area, presumably the employer's right of control over those drivers is going to be the same for everyone, even if the control is only exercised sporadically. This comes from the fact that tort liability, which is where it all comes from here, is not about whether you actually did tell your driver to go too fast, run a stop sign, kill a family of 4 in their minivan on the way home from church. The question is whether you could have told your driver not to. And so it comes to the right of control, not the actual use of it. But if you're going to shift the emphasis one step to a test of entrepreneurialism in the first place, there's no reason not to make it actual entrepreneurialism instead of potential. Even if we aren't allowed to talk about which form of the test does a better job of actually carrying out the purposes of the statute, I think it should be clear that the right to run a furniture delivery business on the weekend in your FedEx truck doesn't really make you any different from a factory worker who has a truck that he uses on the weekend or could use to do the exact same task. The factory worker is still an employee of the company whose capital he's making productive. I think it's fair to say that looking at actual entrepreneurialism will cut a finer line between workers who are independent in at least some meaningful way and workers who are more like employees. By contrast, if you want to focus on potential entrepreneurialism, you're essentially opening up a whole new range of areas for the employer to manipulate contracts by inserting opportunities that may or may not be realistic or actually desirable. So my proposal is that simple. In a case like this, the court would take a look at a group of employees who are seeking union representation, and if half of them are essentially owners of a small business, employing other individuals to do their work, owning large areas of capital by, for example, having multiple routes and multiple trucks, under this test, those people could be independent contractors. But if half the drivers act like employees in real life, they would be employees for purposes of the statute as well. And if they want to form a union and bargain with their employer as employees, the law would allow them to do that. The real solution, of course, is different from what I've just been telling you. The real solution would be to interpret the definition of employee to extend labor protections to the people who actually need those protections, without worrying about some irrelevant common law test. Some states, like Massachusetts, have already sort of gone this route as far as state law protections are concerned. And they have stricter laws that are designed to actually accomplish this. In some countries, for example, Canada, Germany, and Sweden, there's actually a category of worker in between employees on one hand and independent contractors on the other hand. Logically, it's called the dependent contractor. Those individuals are probably the best classification for FedEx drivers because they happen to be economically dependent on a single company, even if they have other indicators of lack of control or entrepreneurial potential. But unless the Supreme Court dramatically shifts course and eliminates this idea that you can't rely on the purpose of a statute, all of these changes would require legislative action. Given how hostile Republican politicians tend to be to workers' rights and how essentially incapable the Democrats are of getting anything done, legislative action in this field doesn't seem very broad. That is why, in the end, I think this FedEx decision can be a good thing for workers' rights, even though in this case the workers didn't get the opportunity to form a union. It's an example of a court that's willing to tinker with the common law test and try to improve it. If the court were willing to more finely tune its adjustment, I think it could ultimately lead to a more rational application of a fundamentally irrational distinction. Thank you.
Thank you to Brandon and Rob for inviting me to participate. This is a program that means a lot to me. I think it's a highlight of every academic year, a chance we can come together and celebrate the work of some of our really outstanding students. And so it really is an honor and a pleasure to be here. Some of you know I'm not an expert in labor law. I know very little. I didn't actually even take the class in law school. I'm sorry to say that. If you'd been teaching, I would have taken it. But I do know a little bit about agency law, and agency principles are assumed to be at the heart of the problem that Micah is working on. And I want to say at the outset that it's a fantastic piece of work. It's technically a student note, but it really deserves to be called an article, whatever that means. It's every bit as substantial, as learned, as thoughtful, and as carefully written as a law review article by a tenured professor we hope would be. It's really a fine piece of work. I'm supposed to comment on it, part of my job. I know you guys are expecting me to come up with some kind of insightful criticism, show an error that he made somewhere. I couldn't find anything negative to say about it. I'm glad I couldn't. It's a really fine piece of work, and I'm very proud of him for having written it. He's dealing with a huge issue. The distinction between employees on the one hand and independent contractors on the other is of incredible importance in our country and in our economy. Whether you're an employee or not determines whether you can join the labor union, whether you can join with other people and bargain collectively for higher wages, for better working conditions, for better employee benefits. Labor law unions are not obsolete. Of course, Mike is right about that. And the reason is simple, because people who individually have no or very little bargaining power amplify their bargaining power when they can join together and bargain collectively. Because then collectively, if they can't make the deal that they think is appropriate, they can walk away, and the union, the employer, is in a bind when it happens. If an individual does that in a competitive economy, it may not be a big deal at all. So, lots at stake there. The bargaining power issue is important, and unions are fundamentally important for that purpose, and always have been. On the other side of the issue, of course, for business, it means higher costs, right? Higher wages for workers means higher costs for business, and that's the other side of the coin. Employees also, as Micah mentioned, enjoy all kinds of other, employees versus independent contractors enjoy all other kinds of legal protections as well. A whole range of federal legislation, state legislation, gives people who are denominated employees a wide range of rights that they wouldn't otherwise have. Of course, this also means higher costs for employers who are also subject to certain tax burdens and potential tort liabilities if their workforce is deemed to be employees versus independent contractors. So a lot at stake on both sides of the issue. Here, businesses, especially the large corporations, expend enormous amounts of money and ingenuity trying to structure their workforce in the legal status of their workforce in ways that avoid the employee classification. And so, of course, there's a huge amount of litigation about this as well because there is so much at stake. So it is a really big issue that he's taken on, a very important issue, and I'm glad he's done it. Now, as far as the distinction is concerned, the distinction between employees and independent contractors is concerned, it is assumed to rest on agency law principles, a common law of agency. It is this area of agency law is a notoriously vague one. As Micah explained, the guidance we get from the common law, as stated in the restatement, is simply a laundry list of 10 factors, a wide range of factors that are supposed to help us decide whether a particular worker is an employee or an independent contractor. The restatement gives us no guidance as to which factors are more important than others, which are necessary, which are sufficient. And the result is we really don't get a lot of clear guidance from the law on that issue. Often the answer is clear. Somebody will clearly be. There are large numbers of people who clearly are employees, another group that clearly is independent contractors, but there's a big gray area. You've got a lot of people out there who have, whose employment relationship has some of the attributes of employee status and others that might look like independent contractor status. And so the courts and the National Labor Relations Board have to resolve these questions on a case-by-case basis. The results are going to be controversial, again, because there is so much at stake. And lately, at least, the results often are going to be bad for labor. And the case that Micah focuses on primarily, the Federal Express case, is an example of that. The contract involved in that case that all of the drivers signed gives the drivers the opportunity to become independent business owners, to be entrepreneurs. You own your own truck, you own your route, you can hire people to drive for you, you can buy as many routes as you want, you can look like a business owner, you can put capital at risk, possibility of high return, but also possibility of loss. You can be an entrepreneur, you can be an independent business owner as a FedEx driver if you want to do that. The contract gives you that opportunity. But you don't have to do that, or at least the contract, as in effect at that time, didn't require that you did that. And so a lot of FedEx drivers chose not to pursue that opportunity and look, act, behave, think of themselves as if they are employees, not as independent contractors. And that comes as no surprise, right? Because psychologically, you know, the world is divided into people who want to be employees That's most of us. Highly paid employees, hopefully. So and then there's other people who want to be entrepreneurs, don't care about the stability of regular employment and a monthly paycheck. They want to be able to, try to hit the home run, and they're willing to take risks in order to do that. Some FedEx drivers think about themselves that way, others don't. The D.C. Circuit, in this case, moved away from the traditional focus on control and other common law factors that are listed in the restatement in favor of this new test that focuses on the question of whether the drivers are independent entrepreneurs or business owners. And what the court did there, and Micah said this, but important to appreciate this, the fact that the contract gave every driver the opportunity to be an entrepreneur, even though many or even most of the drivers did not take advantage of that opportunity, continue to act like employees. The possibility or opportunity to be an entrepreneur, the court said, was enough to convert everybody into an entrepreneur. Therefore, you're all independent contractors. None of you is an employee. None of you is allowed to organize, to form a union. When you see a decision like this, the law is vague and strongly indeterminate. The stakes are high. The question is politically, ideologically charged. Everybody has strong views about unions. You think they're good and they're important in our society, or you think they're bad and they're bad for business, bad for productivity, and all of that. Vague law, high stakes, highly politicized question, and you think the result is wrong. You may be tempted to say this isn't law at all, this is just politics, this is just the judge's personal political preferences. And then you read a case like this, if you're old, and you're cynical about these things and dispirited, depressed a lot of the time about the way the country is going. This is just the latest in a 40-year history of an organized assault on workers' rights. And you think it's law, it's not law, it's just politics. The great thing about Micah's article is that he does not succumb to that kind of cynicism. I'm sure you were tempted at times, but he takes, this is important, he takes the legal analysis really seriously. And then he shows how it doesn't make sense according to its own logic, and then he proposes an excellent alternative approach. He offers two powerful and really important critiques of this FedEx opinion. First of all, he points out that the court in this case and in other cases on dealing with the same issue have developed this test with explicit disregard for the policies underlying the labor laws. He said this. This should strike you as incredible and even crazy. You've got a test that is indeterminate, a laundry list of factors, very hard to say how the case should come out looking only at the law, and yet we're not supposed to think about the policy underlying the labor laws in order to resolve the issue. You guys know that already, at least if you've been in my class, you know that. When the law is unclear, as it often is, not always, but often is, you can't just make something up. You need to think seriously about the policy, about the reasons for the legal regime that we're talking about. And in this area, Micah tells us the courts are not doing it. That is not good. That is bad. That's not the way we should do things. And then he also offers a devastating critique of the court's own logic in the FedEx case. And even if entrepreneurship is a relevant or maybe even the relevant criterion, and he thinks, and I think he's right, it may be, if a FedEx driver truly is a small business owner, putting his or her own capital at risk and all of that sort of thing, with the ability to bargain with the corporation for the terms with which it's compensated and all that, then maybe the labor law protections really don't apply. But it makes no sense to treat all of the drivers like that, all of them as business owners, if they're not. The contract allows them to do that. Some of them do, but many of them don't. And Micah says, and this is, when you read it, you think, wow, this is great. This is obvious. I mean, really good arguments after you thought about it were obvious. It wouldn't have been obvious to me if I had approached the problem. But having read his analysis, he's got to be right. The right way to do this is take worker by worker. If you've got a group of workers who are behaving like independent business owners, really are independent contractors in some meaningful sense of that term. And you got another group who look like employees, or are subject to the control of their employer, have no desire to be small business owners or entrepreneurs. You've got to treat the two groups differently. And the ones who are acting like employees as opposed to independent contractors ought to be allowed to unionize. It's a great argument. I think he's right. And it's a very effective critique of the reasoning in that case. So what he does is take the existing legal standard as formulated by the DC Circuit and show how it was applied in ways that defy the test's own logic. And this is based on his own sophisticated understanding of the economic realities. And by the way, the paper includes a very thoughtful analysis of just what it means to be an entrepreneur in a context like this. So what we end up with then is really what I think is the best kind of lawyer's argument, the best kind of legal argument. You take the court's reasoning seriously. You don't dismiss it as a sham, just politics masquerading as law. No, you take the court's reasoning seriously. You read it carefully, take it seriously according to its own terms. Then you look carefully at the facts, and then you explain the error in the analysis if there is one, and that's exactly what he's done. And I think that's a great achievement. In a time of conservative ascendancy, which is where we are now, it's going to get worse. This is me, my own personal views, okay, disclaimer, preaching and all that. It's going to get worse. It can be hard for people on the left to have much faith in the law as a vehicle for social justice. Sometimes it seems like the political forces are just too powerful. But we have to remember, we have to keep in mind that important battles are still being fought in the courts, and legal argument supplies the primary weapons. And so, for me, Micah's article is a great, a wonderful, and inspiring example of how legal argument might actually make a difference. And as such, it should serve as a model for all of us who value social justice. Thanks.
I'm not sure this is part of my role. Most of you here know David Millen of our own faculty. We have as the second commenter Jeff Hirsch of the University of Tennessee School of Law. Jeff is a leading teacher and scholar in the labor and employment area. It was great of you to come down to do this, Jeff.
Thanks. Well, it's my real pleasure. This is a fantastic program, so it's quite an honor for me to be able to come and participate in it. Also, I have to note that the fact that I played a small role in the genesis of this in a blog posting I did, sort of when I slog through the blog at times. This gives me a little extra incentive to know that it might serve as a catalyst on occasion. Now, my first comment is much like Professor Millen's, that my biggest complaint about Micah's paper is he doesn't give me enough to criticize. He does a fantastic job explaining sort of where the law has been, the problems with the current law, and takes a very intellectual and reasonable view of perhaps where it should go. So in light of that, what I'm going to try to do is perhaps pick up a couple areas where he left off and walk it a little further and see perhaps if I can add just a little bit more to some of the ideas he's talked about. One of those that I'll talk about later is perhaps adding a little bit more about what we might think about if we're actually seriously considering reforming this particular area. Although, as he notes, not always the most optimistic exercise given the current inability of Congress ever to change the NLRA. Before I get to that, though, I do want to talk a bit more about how the D.C. Circuit got to where it ended up in the FedEx home case. The idea that entrepreneurial opportunity, particularly the theoretical opportunity, is really now the crux of the debate whether or not a worker is an employee or an independent contractor. And I think this development is important for a couple of reasons. One of which it's going to, I think, play a bit into what the board may be able to do to address the problems it sees with this decision. And I should just note, right, I used to work at the NLRB, and I can tell you as a fact that the board is quite concerned with the D.C. Circuit's trend in this area. So they will be looking for ways to perhaps change this. Secondly, I think the development's important because, for one, it shows kind of how convoluted and warped sometimes these cases can get. And it perhaps serves as a little bit of a warning that sort of non-legislative solutions are going to have their limits. Right? Again, Mike is quite correct that that's probably the reality of the situation. But that's sort of an added unfortunate aspect of that, because there's, I think, as I'll talk about a little bit later, there's real limits to what a non-legislative solution might do. So in talking about the development of this case, right, it really isn't FedEx, the FedEx decision, as Micah talks about in his note, where the real genesis is an earlier case called Corporate Express. And in that case is where the D.C. Circuit expressly says, look, we're going to move the analysis away from focusing largely on the control of the manner and means of work, and then go instead to the entrepreneurial control. And what was interesting about that is the D.C. Circuit wasn't claiming to do that on their own initiative. Instead, what they said is, we are only doing this because the board and general counsel are asking us to. And in fact, we might actually have gone a different way if they hadn't asked us to do this. Blaming them for their own demise, if you will. But what's interesting about that is if you look and see actually what the board and general counsel actually did, right? The court actually cites only one particular page in the decision, which actually goes to the ALJ decision, which the board sort of adopted with modification. And if you look at that, to be perfectly blunt about it, the board never said anything even remotely close to that. What the board simply said was, yeah, they did look at the entrepreneurial control, because given the facts of that case, it was a salient feature of the analysis, right? But it also looked at all the other factors, or at least the relevant factors that you typically see under this common law test. The board itself, in its own opinion, did the exact same thing, ran through the various factors. Entrepreneurial opportunity was certainly one of them, but not by any means the only one. So what was going on? What appears to be the situation is the board's appellate court brief. For those of you wondering if you actually ever have an influence as a lawyer, this is one case where perhaps unintended consequences, but there was an influence here. And in that brief, what the board general counsel said was, it looked at past D.C. court decisions in this area and said, we're a little concerned that at least one interpretation of your decisions is putting this control over the means of work on this pedestal, sort of the greatest among equals of the various common law factors. And we don't think that's proper. Right? That's absolutely true. But what the general counsel never said was, and we think you should replace that with entrepreneurial opportunity. In fact, what they explicitly said is, we think you should consider that along with all the other factors. Now, where the D.C. Circuit got this idea that there should have been this shift to entrepreneurial control, I don't know. You know, charitably, it was just a misinterpretation. Perhaps there was something in the oral argument. I actually don't have access to the argument transcripts, but that maybe there's something in there. But the bottom line is the board itself never said this, right? And even if it did say this, right, there are several reasons why the court should have never gone along with it, right? First of all, some basic sort of administrative law principles under the Supreme Court's Chenery Doctrine. Agencies aren't allowed to defend their decisions on grounds that they didn't use in the decision itself, right? A court is not supposed to enforce a decision based on different grounds. And I can speak from practical experience as a board appellate attorney. The D.C. Circuit is well aware of this rule and is not afraid to use it against the court. And similarly, another aspect of administrative law that the court is not afraid to use is even if the board had actually said, look, we want to move to this different type analysis, right? They have to actually explain why they're going to do that. They have to say, this is why we think we should do this. Right? And not only did they not do that, they of course didn't ask for the change at all. So two sort of basic administrative law principles violated, I think, by the D.C. Circuit. Not to mention the not insignificant fact that it goes directly against the Supreme Court's own precedent. Right? The Supreme Court, as Mike has noted, has repeatedly said that this is a multi-factor test. Right? You need to consider all the factors. And so it's this very sort of interesting way in which this rule was developed. And the board perhaps, in an optimistic moment, could take the view that, well, for once they're actually giving us a lot of deference, which they normally don't do. The D.C. Circuit in particular is aggressive about sort of telling the board what they think should occur, especially Judge Edwards on the D.C. Circuit, who was on this Corporate Express as a former labor professor, and is not shy about letting you know it. But to the extent that the board might have had hope that increased deference was in its future, right, the FedEx opinion squashed it, right? Because in the FedEx opinion, the board is certainly not arguing that entrepreneurial opportunity should be the main feature, right? They're using this multi-factor test, relying on control and the other features, and there the court doesn't defer at all, right? It's almost this weird, bizarre view that, well, we'll let you change once, but then we're going to lock that down and not let you change again, which of course is not the way administrative cases are supposed to work. So now where does this leave the board? Right? There's sort of a negative view and a positive view of this. Right? The glass half empty view is, of course, once you have an opinion like this set forth, it's really hard to move it. Sort of judicial inertia occurs. It's almost like a bad game of telephone. Right? It's sort of, once it gets in place, it's really hard to move things along. Moreover, it's particularly hard for the board to change something like this when it occurs in the D.C. Circuit. And this is for a couple reasons. One is the D.C. Circuit alone among the other federal circuits, has potential jurisdiction over any NLRB case. Any party can bring a case before the D.C. Circuit no matter where it occurs. And so employers, not stupidly, are going to go, that are concerned about this and want to use the D.C. Circuit's rule, are going to file there. And the board traditionally won't. They'll give losing parties time to file first. Moreover, the D.C. Circuit, perhaps notwithstanding this particular analysis, is generally widely respected among the other circuits. It's viewed as an expert in administrative law and board law. And so the other circuits tend to, not totally defer, but they definitely take the D.C. Circuit's view into account. Right? So there's a real trouble that perhaps this is going to spread even beyond the D.C. Circuit. Now, the glass half full view of things starts, first of all, with the fact that it's not necessarily true that the other circuits are going to adopt this. If the board, for instance, applies its non-acquiescence policies, policy basically saying, we know you said this, D.C. Circuit, we disagree with it, and we're going to keep applying our rule in the other circuits. Usually, again, I'm speaking from experience, not the most popular view to bring to a court, but it can work on occasion. And in fact, recently, some of you may be aware that there was a Supreme Court decision involving the board's ability to issue decisions with only 2 members. The relevant aspect of that case was that the D.C. Circuit was alone among the circuits that said they didn't have that power. Now, they ultimately won the Supreme Court, but all the other circuits to look at that disagreed with the D.C. Circuit. So it can happen. I think more importantly, though, for the board, is that, particularly given the way this case is developed, they have a real opportunity to actually get the D.C. Circuit to shift itself. And the way I think they might be able to do this, obviously might, I emphasize highly here, is to say, look, even if we agreed with you that we in fact asked you to shift to entrepreneurial opportunity, we are now explicitly stating we want to change, and here's why we want to change. Whether it's a multi-factor test or some other sort of gloss on the test that the Supreme Court's told them they must use. I think in that way that will allow even a panel of the D.C. Circuit to actually agree with the board, defer to their view as reasonable, without directly criticizing an earlier decision by the court, which is, that's a concern for all courts. They're unlikely to do that. And in fact, I think there's probably a significant number of judges on the court that would be sympathetic to that. The board actually sought an in-bank panel in the FedEx case and lost only by a 6-5 margin. So it's definitely, I think, a possibility. Whether it happens or not, I don't know. Now, of course, even broader than this, even if we move beyond the D.C. Circuit's own sort of unique view of this, right? As Micah has talked about, right, this whole area is a big mess, right? Even under the traditional view that we've had for decades, Micah's done a fantastic job explaining why, in fact, it's really done a disservice to workers, I think, particularly under the NLRA. Now, perhaps what few differences I have with Micah would be on whether or not tinkering or adjusting the test in a non-legislative fashion would really have a major impact. And perhaps the pessimist in me thinks that maybe there's a few marginal cases that might flip based on perhaps a different view. In the large majority of cases, at most, the language is going to change, and the courts are going to sort of do what they want to do anyway. And so, although admittedly unrealistic, I do think if we're going to have a really serious shift in this particular area, it's going to have to come legislatively. Again, probably it's not going to happen. And where I do absolutely agree with Micah, though, is that if we are going to do that, there really needs to be an explicit incorporation of the Act's policies. right? As he's talked about, right, one of those express policies in the Act is unequal bargaining power among workers, and so the low wage, low human capital workers that he talked about, or certainly can get that consideration can be used in these cases, right? Another policy of the Act, I think, that is in the Act, that I think is important is the fact that the Act is intended to encourage collective bargaining as a less disruptive way of resolving workplace disputes, right? Way in which it's not going to, halt factory production during times of war and, various times like that. And I think that can actually play an influential role in these cases, right? The sort of high-flying Silicon Valley independent contractor programmer who has no desire whatsoever to be an employee, right? That worker and whatever company he happens to be working for, right? They're not going to have a whole lot to talk about, right? The collective bargaining between those parties isn't going to be that fruitful. Whereas if you have drivers in a FedEx type situation, right, even though maybe in certain aspects they might look like independent contractors, right, bargaining actually will be quite useful in that case. There are quite a few things they can talk about, particularly given the indefinite status that those workers have with the various companies. So I think that is important. The other aspect to it that Micah talks about a bit more in his note is, I do think as well that there needs to be a continuation of a multi-factor test, right? He talks about it in one brief portion that there's a real danger in trying to narrow things down to one specific or even just a few specific factors, right? You might have a situation where if you're looking at entrepreneurial opportunity, even on a worker-by-worker basis, as he talks about, right? It may be clear on that somebody might be considered an independent contractor, but there may be a whole panoply of other factors that point the other way. And I'm usually the first in line to try to simplify a test, but I think this is one area that is so context-driven that you really need to open things up and consider whatever factors might be relevant. And this is frankly something that the board is well used to doing. They do this in a lot of other situations, including the employee-supervisor situation that Micah talked about. Now, one final aspect of this, and this actually relates to sort of a non-legislative alteration of the test, is I think we also need to think more about what sort of incentives are at play in these cases. Right? You can have the best test in the world, but the problem is the fact that both enforcement and compliance are quite difficult. This is especially true with the NLRA. Right? The NLRB has no power to issue damages other than back pay. Right? So in most what you're dealing with in a case that involves terminations is a mitigated back pay award. And when you're talking about a representational case like FedEx, there are no monetary damages at all. Right? On the other hand, there's of course huge benefits, monetary benefits to a company to avoid employee status. So I think giving the board power to fine companies perhaps in these situations, especially for willful violations of misclassifications, are useful. There in fact is just last month there was a reintroduction of a bill to amend the Internal Revenue Code that would actually look at this more, even give some sort of pre-clearance or pre-classification of workers, which I think would be helpful. The other aspect, the final aspect of this I'll talk about, and I will then sit down as I see the clock ticking on me here, is even at a substantive level, even before we get to enforcement, right, we need to think about what employers' incentives are, and if they want to take advantage of the benefits of independent contractor status for their workers, they need to be forced to accept the cost as well. Right? Because what you're ending up having, and again the FedEx case is a prime example of that, is companies are basically having their cake and eating it too. Right? FedEx is able to present these drivers as an independent contractor. They avoid any labor and employment coverage for them, taxes. Right? But on the other hand, the drivers have to wear the uniform. They have to have the trucks that say FedEx. They have grooming standards that apply to them. FedEx has this workforce that, for all intents and purposes, and for their customers, from their customers' viewpoint, appear to be workers. They're gaining all the goodwill from that results from that, without paying any of the costs. So I think what we need to make sure is that whether it's adjustment of the current common law rule or something legislative, is the board is actually looking at all these factors and thinking about, is the employer actually accepting the cost of this independent contractor classification as well as the benefits? And again, even that's not going to be a panacea, but I think that will, among other things, push the analysis more in a direction that we want it to go. And so with that, I will sit down and again congratulate Micah on a fantastic job.
See why this is one of my favorite events. We're going to take a 5-minute break and come back at 5:07, and then I know that Aaron is going to wow us in exactly the same way that Micah did.
It's an honor for me to introduce Aaron Sims to you this afternoon. As a member of the faculty, I marvel every year. Come on in, folks. No problem. Just introducing Aaron. As a member of the faculty, I marvel every year at the outstanding quality of the students who enroll at W&L, and Aaron Sims embodies, for me, that excellence. From the moment I met him in my first year course in administrative law, I saw in him a fertile imagination, an incredible seriousness of purpose, an unflagging work ethic, but most of all, a willingness to jump in the conversation. And that's what we like here at W&L. And Aaron jumps in intrepidly into the conversation. And it has been a pleasure to be his teacher in administrative law and in my other course on mass media law. He's been a superb student, and he's been that for many years. He graduated magna cum laude from George Wythe University in Utah in 2007. During that time, he intrepidly completed a 2-year mission for his church in none other than Las Vegas. That takes some quality there. That takes a lot of intrepid character and commitment, which I totally admire. After graduating from George Wythe University, he worked as a journalist on a Maryland newspaper, where he covered the court system, and he also was allowed at times to write human interest stories about some of the colorful characters and strange events in that part of Maryland. He then came to Washington and Lee. He has worked in the summers for first a federal district court judge, and last summer as an honors intern at the Federal Aviation Administration, where he was able to see administrative law in all of its raw glory in the federal system. When he made law review, he was looking for, I think, a separation of powers issue. The constitutional structure of government had captured this young man's imagination, I'm sure long before law school. And I think he wanted to explore the meaning of the separation of powers in a new context. So the whole phenomenon, the whole problem of SIGTAR captured his imagination and proved a good vehicle. Aaron aspires to some very interesting things. He wants to practice law with his brother, and maybe if we can get his sister to come to law school, it'll be a threesome in that law firm. But he also wants to do something for the homeless in Washington, D.C., another admirable goal. And he wants to start a nonprofit to get the message out about certain first principles that have been important in this country. The Constitution, among other things. So regardless tonight of what you think about the separation of powers and how it should apply, I think it's going to be really interesting for all of us to hear Aaron's analysis of a very contemporary separation of powers issue. Regardless of how you think the separation of powers should work as a doctrine, you will have to credit Aaron for entering that complex conversation and for treating it with the care of a good lawyer and with the concern of a very engaged and involved citizen. So without further ado, Aaron Sims.
Okay. Before I start, I just wanted to say briefly that I had a chance to read Micah's note a couple weeks ago, and I was just blown away at how great it was researched. There was a new source practically in every footnote, which I could not manage to do. So I take my hat off to him. That was great. And thank you to Professor Murchison for serving as my note advisor and for finding this topic initially for me. Your help was very critical. And I appreciate Professor Siegel coming from Washington, D.C., and Professor Scales being willing to speak as well. So I'm going to hop right in. The statute at issue in my note is the Emergency Economic Stabilization Act of 2008, also called EESA. This created the TARP program, the Troubled Asset Relief Program, where the government allocated $700 billion to buy troubled assets such as residential and commercial mortgages, related securities, and other difficult-to-sell resources. Under recent estimates, the total federal government expenditure under this program could exceed $23 trillion. So this is a major piece of legislation. EESA also created the Special Inspector General for the Troubled Asset Relief Program, also known as SIGTARP. Congress allocated to SIGTARP the authority to recommend to Congress, to the Treasury Department, certain actions with respect to Treasury's management of the TARP funds. A little bit about SIGTARP. He's appointed by the President, confirmed by the Senate, removable from office by the President, and his existence is coterminous with the existence of the TARP program. Like most inspectors general, SIGTARP's primary duties include auditing Treasury's expenditures under the TARP program, making recommendations to Treasury with respect to their expenditure of the TARP money, investigating allegations of fraud or abuse, preparing quarterly reports and giving them to Congress, and keeping Congress fully and currently informed on SIGTARP's activities. SIGTARP's powers include accessing all TARP-related documents, conducting investigations, requesting information and assistance from federal and state agencies, subpoenaing information and data, and having direct access to the Treasury Secretary. This is SIGTARP. His name is Neil Barofsky. He was sworn into office December 15, 2008. He went to law school at NYU. He was a federal prosecutor for 8 years in the Southern District of New York, so no doubt he gained some valuable experience there while he practiced in the mortgage fraud group and the securities and commodities fraud unit. So what's so unique about SIGTARP? What is so different about him as compared to the 60-plus other inspectors general in the government right now? The organic statutes for the other IGs explicitly require that these inspectors general report to their respective agency head, keep their agency head fully and currently informed, and to be supervised by their agency head. However, SIGTARP, in bold contrast to that, the EESA does not explicitly require that SIGTARP report to or to be supervised by an agency head. It makes no explicit reference to any agency head, and in fact, it doesn't even make clear in which department SIGTARP is part. Furthermore, the EESA requires SIGTARP to submit reports to Congress, but does not require SIGTARP to report to any other entity. And this arrangement distinguishes SIGTARP from all other inspectors general. Uncertainty regarding SIGTARP's autonomy caused a lot of tension in mid-2009 between Treasury and SIGTARP. Barofsky demanded from Treasury certain TARP-related documents stemming from the AIG executive compensation issue, and Treasury said, no, we're not going to give them to you. So SIGTARP then threatened to go to Congress and say, well, I'm going to make you guys give me these documents. So there was a big clash. It was all in the news. On one hand, you have Treasury Secretary Geithner saying, SIGTARP is part of Treasury, and we have the ability to supervise him, and we need to tell him to settle down a little bit. Barofsky, on the other hand, says, well, SIGTARP is an independent entity within Treasury. However, pursuant to the congressional intent as articulated in the statute, it's not subject to Treasury supervision. So all of this culminated in Treasury requesting from the DOJ Office of Legal Counsel a legal opinion on the extent of SIGTARP's independence from Treasury. But before the OLC responded, Treasury decided to back off and withdraw its request for an opinion. So Barofsky takes that as an acknowledgement that Treasury backs off, admits that SIGTARP is an independent entity within Treasury, and that he's not subject to any supervision. So with that background in mind, let's take a look at the problematic portion of the statute. The statute provides that the Treasury Secretary shall, 1, take action to address deficiencies identified by a report or investigation of SIGTARP, or 2, certify to appropriate committees of Congress that no action is necessary or appropriate. And this will become more clear why I argue that this violates the separation of powers further in my presentation. Before we can understand why it violates the separation of powers, let's just have a brief overview of the Supreme Court's precedent regarding separation of powers issues between Congress and the President. The two main cases that apply here were Boucher v. Sinar and Morrison v. Olson. Any administrative law student probably gets real comfortable with these cases. The consolidated rule that we glean from these two cases is Congress, 1, may not impermissibly interfere with the President's ability to fulfill his constitutional role, and 2, Congress may not itself control the execution of its laws. So why does this portion of EESA violate the separation of powers based on that doctrine? EESA's language provides that the Treasury Secretary must act to address TARP-related deficiencies as recommended by SIGTARP, or certify to Congress that no action is necessary or appropriate. Pursuant to my argument, however, this is what the statute really means. Treasury Secretary must, 1, implement any SIGTARP recommendation that is either necessary or appropriate, or certify to Congress that no action will be taken because the recommended action was both unnecessary and inappropriate. So, arguably, EESA imposes a severe constraint on the executive's ability to execute TARP by obliging the Treasury to comply with any SIGTARP recommendations that are either necessary or appropriate. Parsing through the statute requires that Treasury certify to Congress that no action is necessary or appropriate. Well, what does certify mean? On one hand, it could mean just a very bland certification, no action necessary or appropriate, just sort of parrot the statute, the statutory language back to Congress. On the other hand, it could mean that Treasury actually has to explain itself to Congress. The legislative history, which I spent many hours parsing through, suggests that certify means that Treasury must explain to Congress the reason for not following SIGTARP recommendations. Now, next, the statute provides that makes a distinction between necessary or appropriate. Treasury must implement any recommendations that are either necessary or appropriate. The statutory language does not say necessary and appropriate. So if either term is satisfied, the recommended action is mandatory pursuant to my argument. The only other option, as given by the statute, is to certify that the action is neither necessary or appropriate. Treasury only has two options: implement the action or tell Congress that it's both unnecessary and inappropriate. So if SIGTARP recommends an action that is either necessary or appropriate, Treasury must take that action because the Secretary can't, in compliance with the statute, certify that it is unnecessary and inappropriate. So does this necessary or appropriate clause violate the separation of powers? Well, the court in Morrison determined that a very similar situation did not violate the separation of powers. The court in that case said that Congress did not retain for itself the power of control or supervision over the independent counsel and did not attempt to increase its own powers at the expense of the executive branch. So in plain English, what does that mean? What's the rule we get from that? The court will tolerate congressional restriction of executive discretion as long as the strict discretion is not absorbed by Congress. So in other words, Congress can restrict what the President and what the executive branch can do as long as Congress does not seek to aggrandize itself at the expense of the executive branch. So how does this apply to SIGTARP? As long as the discretion that is stripped from Treasury is not absorbed by Congress, there's no separation of powers concerns. So what's the lost discretion here? What's the discretion that's been taken away by Congress from the executive? It's the discretion to execute EESA and to administer TARP according to the executive's own prerogative. Well, who absorbs this discretion that was taken away from the executive branch? It's SIGTARP. SIGTARP has the ability to tell the executive branch, implement this recommendation unless it's necessary and unless it's unnecessary and inappropriate. Well, the question becomes, who controls SIGTARP? If Congress controls SIGTARP, then it's basically Congress controlling the execution of the statute. If the president controls SIGTARP, we've got no separation of powers concerns. I don't have a note. So who controls SIGTARP? Let's look at three factors here. First, independence from the executive supervision. SIGTARP reports only to Congress. He's not supervised by Treasury. The tense relationship with Treasury. Inspectors General by nature operate as congressional affairs, and the prime role is to expose corruption in the executive branch. SIGTARP has already demonstrated that he has no qualms about butting heads with Treasury. The final element is SIGTARP's loyalty to Congress. I think Congress summed it up best in the legislative history to the Inspector General Act of 1978 when it said, Inspectors General were fashioned by Congress such that their responsibility runs directly to an agency head and ultimately to Congress. And SIGTARP again has demonstrated recently its loyalty to Congress when Borowski threatened to go to Congress if the executive branch did not give him the documents that he wanted. So the real question is, under which case does this SIGTARP issue fit more fully? Is it a Boucher issue or is it a Morrison issue? Under Boucher, Congress retained the removal power over an independent officer who exercised executive power. So in essence, Congress controlled the exercise of executive power and thus controlled the execution of the statute. On the other hand, in Morrison, Congress retained absolutely no removal power over the independent officer who exercised executive power. So although the president's removal power was restricted, Congress neither absorbed that strict discretion nor controlled the exercise of executive power. So under which case does SIGTARP fall? Well, let's look at the arguments. What makes it a Morrison issue? Well, the president retains removal power over SIGTARP. That's huge. On the other hand, practically every other factor cuts toward classifying this as a Boucher issue. SIGTARP reports only to Congress. The executive can't comment on those reports. He has unrestricted access to executive documents. He responds to congressional requests to testify and to produce info on Treasury's management of TARP. He speaks to Congress without executive permission. He functions impervious to executive supervision. He's already demonstrated that he has a very tumultuous relationship with Treasury. And he's basically on an errand from Congress to expose corruption in the executive branch as an Inspector General. So the issue really boils down to the removal power. The only reason that cuts towards classifying this as a Morrison issue is that the president can remove SIGTARP. So is that enough to make this not violate the separation of powers? Does congressional assignment to the president of the removal power over SIGTARP transmute what would otherwise be a Boucher issue into a Morrison situation? In other words, is the removal power dispositive in determining the level of congressional control over the execution of the laws that qualifies as a violation of the separation of powers principle under Boucher? If the Treasury Secretary must take action on TARP-related deficiencies as identified by SIGTARP that are either necessary or appropriate, and if Congress possesses all control except for the removal power over SIGTARP, then SIGTARP's capacity to compel executive action on TARP recommendations borders on congressional execution of ESA, according to my argument. So, but then again, we've got to go back to the fact that Congress does not remove SIGTARP. The president retains the removal power. So what are the arguments for why this is still a Morrison issue? Argument number one, if Congress tries to control the execution of TARP through SIGTARP, the president can just get rid of them. He can remove them. Well, the counter-argument is that even if the president removes SIGTARP, because he doesn't agree with what SIGTARP is recommending, the office endures. The office is always going to be there, and as long as the TARP program exists, there's always going to be someone with SIGTARP's power. Argument number two is that the president's minimal control over the independent counsel in Morrison was adequate such that Congress did not possess enough control over the independent counsel to constitute congressional supervision of the law. And SIGTARP's situation is very similar to that. But what's the counter-argument? And this was the clincher for me. In Morrison, the independent counsel, the officer there, exercised investigative, prosecutorial, and law enforcement power. He had no ability to shape policy. However, SIGTARP possesses power to recommend to the executive branch actions that must be implemented if necessary or appropriate. SIGTARP basically possesses the power indirectly to dictate execution of a statute. That's policy shaping power. In essence, SIGTARP can commandeer the whole executive machine to execute the ESA according to SIGTARP's recommendations. And I believe that this transmutes the situation from Morrison to Boucher, because Congress cannot reserve for itself an active role in the execution of the laws. So I argue that this violates the separation of powers. So what needs to be done to fix it? The first thing is that we need to diminish Congress's control over SIGTARP, and I recommended several amendments to the statute, namely increasing SIGTARP's accountability to Treasury, providing that SIGTARP functions within the Treasury Department and is subject to Treasury supervision, mandating that SIGTARP report to Treasury, and permitting the Treasury Secretary to comment on SIGTARP's reports to Congress. Second, I had to deal with the either-or ultimatum. In the previous statute, Treasury, I had two options. It could implement the recommendation, or it could certify to Congress that no action was necessary or appropriate. Well, I got rid of that either-or ultimatum and proposed that the statute be amended as follows. The Treasury Secretary shall consider deficiencies identified by a report or investigation of SIGTARP or other auditor engaged by the TARP, and certify to appropriate committees of Congress with respect to how the Secretary responds to such deficiencies. The Secretary's certifications to Congress shall be made available to the public, subject to other requirements such as national security, within 24 hours after submission to Congress. So how does this disarm the ESA's formerly compulsory component? First of all, the amendment eliminates the either-or ultimatum. However, in the words of Justice Jackson, I believe this is sort of a workable solution, because SIGTARP continues to recommend TARP-related actions to the Treasury Secretary, who is obliged to consider these recommendations, and the Secretary must certify to Congress on how he responds to these recommendations. Furthermore, the executive branch is accountable to the public for how it responds to these recommendations. If the executive branch irrationally spurns SIGTARP's recommendations in the proposed amendment, it is the people who should rectify this choice through the political process, through their representatives. So I've talked about why this violates the separation of powers, and why the statute should be amended to preserve the separation of powers, but why is the separation of powers so important? Why would we spend an entire law school class talking about this antiquated topic that was created by our founding fathers back in the late 1700s? Why is it so important? Well, the purpose of government is to secure to individuals their rights and freedoms, such that individuals are able lawfully to pursue life, liberty, and happiness, unrestrained by interference of others. So citizens, however, surrender certain rights for the public good and entrust their leaders with the power both to protect their retained rights and to govern the affairs of civilization in a way that best facilitates the pursuit of happiness. However, human nature is afflicted by the tendency to abuse power. We can just look past on history and see this happen time and time again. The founders realized that the allocation to mortals of authority to govern must be accompanied by safeguards sufficiently potent to counteract the tendency of leaders to abuse their power and to oppress those over whom they preside. So, to guard against power's inclination to consolidate, the founders undertook a structure of government that was separated into three distinct branches, because they realized that tyranny happens when the power of the three branches unites under one entity. They realized that mere parchment barriers as set forth in the Constitution were not enough to maintain in practice the kind of separation that they wanted to create. So that's why we have the system of checks and balances that pervades our Constitution, to preserve the system, the three distinct branches of government, to preserve the separation of powers. So if you really think about it, our entire governmental structure, as articulated in the Constitution, is based around preserving the separation of powers. So, looking to the future, most likely Congress is going to respond to future crises by undertaking more bold, innovative legislation. To ensure that the separation of powers is not sacrificed to efficiency or to innovation, the people, as the sovereign entity, must protect it. That imposes upon them a responsibility to educate themselves about the separation of powers and other constitutional principles so that they can gauge the constitutionality of governmental action and discern departures from constitutional norms so that they can quickly rectify these issues through the political process. And while the Supreme Court and other courts play a very major role in this process, it is we the people who ratified the Constitution, and we play a major role in this also. Thank you very much.
Our first commenter is Professor Jonathan Siegel, who graciously came from Washington, D.C. this afternoon. He's a professor at George Washington University School of Law, where he teaches admin law, federal courts, civil procedure, and I think IP as well. So let's welcome Professor Siegel.
Thanks very much. Let me just mention I am giving this talk in my academic capacity. I'm currently on leave while I work for the federal government, so I'm required to point out that this talk reflects my personal views. This is not government endorsed. With that disclaimer out of the way, I would like to start by thanking Robin Wilson and Washington and Lee Law School for inviting me down here, and also for conceiving of this excellent symposium. I think it's just a great idea to have this forum to highlight student scholarship. Student scholarship should be encouraged in every way, so I think this is a terrific idea. So let me begin by singing the praises of this fine student paper. First of all, I think Mr. Sims has chosen an excellent topic. The constitutional status of inspectors general has not received the thorough attention that it deserves, and the Special Inspector General for the TARP program, or the SIG-TARP, to use the ugly but necessary abbreviation, does have some distinctive characteristics that make him suitable for special attention. And the topic is not antiquated. In fact, it's very timely. The Supreme Court's decision just this year in Free Enterprise Fund suggests that it's going to be taking a somewhat harder line on intrusions into the executive branch. So it's very useful to examine potential violations of separation of powers. So I like the topic. I also liked Mr. Sims's careful attention to the details of the SIG-TARP statute. He very thoroughly cataloged the ways in which the SIG-TARP differs from your ordinary Inspector General. And finally, I thought the whole paper was just very well written, laid out its arguments very clearly, didn't get sidetracked, made good use of authority. It taught me things I did not previously know about Inspectors General and the SIG-TARP, so it was a pleasure to read. So thank you for writing this fine paper. And having said all that, I have to respectfully disagree with the paper's ultimate conclusion that SIG-TARP violates the separation of powers doctrine. Actually, there's a slight qualification I'll add to that later, but basically I disagree with the ultimate conclusion. And in explaining why I feel that way, let's just do a minute or two of theory and then we'll apply it to the particular matter at hand. One thing on which Mr. Sims and I certainly agree is that it's absolutely critical to identify the correct test. There is no universal test in separation of powers law. The landscape is littered with different tests, each of which has its own area of application. Sometimes the test is whether Congress has impeded the President's ability to perform his constitutional duty. Sometimes it's whether Congress has laid down an intelligible principle for the executive to follow. Sometimes it's a multi-factor balancing test. So these are all separation of powers tests, and you have to ask, how do you know which one applies in a particular case? So the answer is you catalog the cases, you categorize the cases according to certain factors. First, you look at the factor that Justice Jackson highlighted in his famous concurring opinion in Steele Seizure. You ask, is the case one of congressional permission, congressional prohibition, or neither of these? So that gives you three categories. And then within each category, you further subdivide them according to which branch is involved. Justice Jackson was only dealing with the executive branch, that's what he had before him, but just as Congress might add to or subtract from the powers of the executive, it could also do the same to itself or to the judiciary. So these two factors, is it congressional adding or subtracting, and to which branch, give you a whole bunch of categories of cases. There are some other factors too, I don't think we're going to have time for them. But these factors alone create some very useful categories where Congress is adding to the power of the executive. The relevant test is usually that of non-delegation doctrine, right? Has Congress laid down an intelligible principle for the executive to follow? Where Congress is restraining the power of the executive, then it's Morrison versus Olson, and the test is, has Congress impeded the president's ability to perform its constitutional duty? Where Congress is adding to its own powers, that's where Bowsher comes in. Also Chadha, that's the link between those two cases. They're both about Congress adding to its own powers, and then you have the test of the non-aggrandizement principle. So this analysis does not resolve the cases. You still have to apply the test once you've identified it, but at least this helps you get to the right test. And then the other thing is, it also tells you which cases to compare your case to, because apart from the pretty hard-edged non-aggrandizement test of Bowsher, the rest of the field of separation of powers is dominated by rather mushy balancing tests. So what you end up doing usually is comparing the matter at hand to the established cases, and the key is to compare them to cases in the same category. So again, it's very important to identify the right category. All right. So having said all that, I can now explain why I disagree with Mr. Sims's conclusion. I disagree with his application of the Bowsher test. It seems to me this is more of a Morrison case. Mr. Sims treats the SIGTARP statute as implicating the non-aggrandizement case, but that case only applies where Congress is giving additional power to itself. Cases in which Congress restrains the executive but does not add to its own power are governed by the Morrison test, as Mr. Sims correctly recognizes. So how do you know which category this case falls in? Well, Mr. Sims suggests that the statute should be treated as implicating the non-aggrandizement principle because of various ways in which he believes that SIGTARP is made loyal to Congress. Well, I think, first of all, that Mr. Sims gives too little weight to the fact that the President retains the removal power over SIGTARP. Mr. Sims says, well, Congress has all the other powers besides the removal power. But you know, that by itself, it seems to me, is not so different from pretty much everybody who serves at the pleasure of the President. If you look through the President's cabinet, putting the military aside, as to most of them, you will not find a statute that says, Secretary of, HHS, Secretary of HUD, whatever, you will not find a statute that says, do what the President tells you to do. Instead, you find a whole lot of direction from Congress. Congress, sets the salary of the cabinet members. It gives them their duties. It orders them to report. It does all kinds of things in that regard. So why do cabinet officials do what the President tells them to do? Well, it's because the President has the removal power. It's because he can fire them if they don't. That's why we have these monumental battles over exactly who is subject to the President's removal power and who isn't. It's because the removal power is the fulcrum. It is the lever through which the President exercises control over the executive branch. So it seems to me that is just critical. But maybe I'm being too formalist. Mr. Sims says, no, look, the SIGTARP is created precisely to be somewhat independent of the executive. He's not supposed to do whatever the President asks just because he could be removed. And the nature of the position is such that the President could get into a lot of political hot water if he tried to exercise his removal power over SIGTARP. Which is all a very important point to bring up. But again, it seems to me it's not so unique. I mean, consider your average U.S. attorney. U.S. attorneys serve at the pleasure of the President. But that doesn't mean they're supposed to do just everything the president tells them to. They're supposed to exercise some independent judgment. I mean, they should follow the president's general programmatic direction. But in individual cases, like, for example, when they might be investigating members of the executive branch, they're supposed to make independent calls based on the facts of each case. And we know the president did get into a lot of political hot water by removing some U.S. attorneys in the last administration. But I don't think any of this transforms them into creatures of Congress. You're still in the executive, even though you're exercising some independent judgment. So I would not put this case in the voucher category. It seems to me it's a Morrison case. And once you put the case in the Morrison category, it seems to me you will find that what's going on here is less intrusive to presidential power than things that have previously been approved. At least, I would say, it's not any worse than the ordinary inspectors general. This is the qualification I mentioned earlier. There is some controversy about the existence of IGs. Generally, I'm not going to resolve that today. But I don't think SIGTARP is so much worse than the ordinary inspectors general that he's unconstitutional. Let's just quickly run through the things that Mr. Sims singles out as particularly problematic. Well, he says SIGTARP doesn't report to the Treasury Secretary, but you know, the Treasury Secretary doesn't report to the Treasury Secretary. I mean, at every agency you've got people who report to other people, but you work your way up the chain, and eventually you come to someone who doesn't report to anybody else. If that person serves at the pleasure of the president, I don't think it can be a problem that he doesn't report to someone else. Mr. Sims also points out that unlike most inspectors general, the SIGTARP files reports directly with Congress without first running them by the Secretary for comment. But I don't know, it seems to me it's true. Okay, the Secretary of the Treasury is not expressly granted the power to comment on SIGTARP's reports, but he's not forbidden to comment. And I don't see what could stop him from commenting. The reports are not secret. I mean, they're posted on the SIGTARP's website. As soon as they're delivered, anybody, I could comment on them. Certainly the Secretary of the Treasury would be in a position to comment, and I don't think it could make a constitutional difference whether the comment comes directly with the report or whether it comes in a separate document. So finally, we come to the point on which Mr. Sims lays the most stress, which is that SIGTARP has the power to identify deficiencies in the TARP program, and it is then, Mr. Sims claims, the duty of the Secretary of the Treasury either to redress those deficiencies or certify that no action is necessary or appropriate. Well, I have two answers to that. First of all, I'm sorry to keep stressing this, but I think this is critical. Even reading this for all it's worth, it's just two officials who both serve at the pleasure of the president who have concurrent authority over some similar affairs, which might be stupid, but that doesn't make it unconstitutional. Okay, but let's stack the deck in favor of Mr. Sims's argument. Let's imagine that SIGTARP was not removable at the will of the president. Let's imagine he could only be removed for good cause and still had this power to identify deficiencies causing the Secretary of the Treasury to have to do something. I still don't think the statute would be unconstitutional. It comes down to how much you read into this statute. And here I have to invoke another important theoretical principle, which is statutes are to be read to save their constitutionality, not to create constitutional problems. So it seems to me the natural reading of this statutory provision is not quite so strong as Mr. Sims suggests. I think it would still leave ample room for the Secretary of the Treasury to do what he thinks best. And you know, there are many situations in which agencies are required to respond to requests for action. Anyone can file a petition for rulemaking with an agency, and the cases suggest the agency either has to do the rulemaking or explain why it isn't. And the explanation is subject to judicial review. There are definitely cases that say Congress can lay down mandatory guidelines for individualized enforcement. And then if someone requests enforcement, the agency has to explain, if it doesn't do it, why not. And that, again, has to be done to the satisfaction of a court. So it seems to me this just creates another situation, the SIGTARP statute, where an agency has to provide an explanation and even assuming that a pro forma explanation that just cited the statutory language would be unacceptable, I still don't think it would force the Secretary to do anything he considered to be a bad idea. I mean, if the SIGTARP says do this and the Secretary thinks it's a bad idea, it seems to me that that necessarily means the Secretary thinks it is neither necessary nor appropriate, or even he might think it's a good idea, but it would just cost more than it would gain, and so I'm not doing it. It seems to me the Secretary could very conscientiously certify in that circumstance that it was neither necessary nor appropriate. So it seems to me, therefore, that the SIGTARP's powers are less intrusive than those approved in Morrison. Mr. Sims rightly points out that the independent counsel only dealt with individual cases. He didn't make policy, but he exercised actual power in those individual cases, a very important power, the prosecutorial power. Whereas all the SIGTARP does is tell some other official, here's what I think you should do, and then it's the other official who actually decides whether to do it or not. So I think this would be okay, even if SIGTARP had removal protection, all the more okay, given that he serves at the pleasure of the President. So, bottom line, I think this is a fine paper, takes on an important issue, does a good job of calling attention to the relevant details, but I disagree with the ultimate conclusion. I think the separation of powers cases permit more flexibility than Mr. Sims would allow, and in particular, to me, I would highlight the fact that the SIGTARP serves at the pleasure of the President, and that the powers he has are less intrusive, I would say, than those that have been approved even for officials who don't serve at the pleasure of the President. That's what leads me to think that this statute would be upheld as constitutional.
Professor Wilson telepathically informs me I have exactly 11 minutes to approximately 24 minutes worth of material, so we will edit considerably. I feel in a great deal from Mr. Sims' paper. I'm grateful for it. I will undoubtedly be turning to it often as I'm teaching APLP next spring. It's fascinating that Mr. Jost's piece should be paired with Mr. Sims' piece today, because they're both coming at their respective problems from, I think, completely different intellectual traditions. And Jost is focusing, how can we really get to the substance that lies beneath this form? And a great deal of administrative process law deals with attention to the form. It's not that Mr. Sims is unconcerned with underlying reality. In fact, he makes his observations about looking beyond some of the superficial ideas. But in fact, it's really more about process. And it's really interesting that we're pairing these two things today. So I do have to report that I agree to some extent with Professor Siegel in terms of my sense of the problems that Mr. Sims identifies. And I'll focus on a couple of things. I'll talk a little bit about the TARP IGs. I can't remember to say SIGTARP. So I call them TARP IG or the Special IG or just Borowski. I'll talk a little bit about the certification process, which really is, I think, a significant concern for Mr. Sims. And I'll talk a little bit more broadly about some background that inclines me towards the view that this is not such a terrible problem. So you can imagine that the TARP IG comes up with a recommendation that might say you should claw back some of that money you overpaid for those bank shares, or stop buying this bad category of loans. And the Secretary can either act to address the deficiencies that the IG identified, or certify that no action is necessary or appropriate. Now, on Mr. Sims' reading, one plausible interpretation is that action could be required when the Secretary finds that action is necessary or appropriate. I'm going to repeat that because it should sound strange to you. You might think that the problem is that the Secretary could be compelled to perform acts that the TARP IG thinks are necessary, but which the Secretary does not. Or you might think that the problem is narrower. The Secretary might be compelled to do something that he finds inappropriate, though the TARP IG presumably does find it appropriate, or perhaps even necessary. But that's not quite what he's saying. He's saying that the constitutional problem arises because TARP obligates the Secretary to take actions that the Secretary thinks are necessary or appropriate, because the TARP IG wants him to. And that is a difficult argument to make. Again, think about the exact mechanism here. Assume that the Secretary does not want to make the recommendations, implement the recommendations the TARP IG suggests. He must then certify to Congress that action was not necessary or is not appropriate. Presumably, if he felt that action was warranted, but he didn't feel like doing it, then, as Mr. Sims points out, he could not so certify. Sims suggests that the Secretary might think that action was necessary, but feel that it was best pursued later, or that action was appropriate, but that other deficiencies might be more appropriate for immediate action. The problem with the first suggestion is that a decision to defer implies pretty convincingly that action now is not in fact necessary. The Secretary could maintain a straight face and say, nope, no action needed here. Of course, as we know, a week is a lifetime in the financial system these days. Maybe the action will be necessary next week, but not today. The same can be said about the term appropriate. Sims must be correct that the TARP IG and the Secretary might have differing views about the relative importance of the IG's recommendations. Thus, some recommendations might be more appropriate than others, while all are at least somewhat appropriate. That might create a situation where the Secretary is being bossed around by an official whom he can't control, but that does strike me as unlikely. First, it's not clear that the TARP IG's recommendations, even if approvingly viewed by the Secretary, have to be implemented wholesale. The Secretary must merely take action to address the deficiencies, which implies a great deal of wriggle room in assigning priorities. Second, given that appropriate is a relative term, I can imagine the same straight-faced Secretary saying, nope, action is not appropriate, pause, because I have to fix other problems first. And Professor Siegel says something similar. I think that does acceptable violence to the term appropriate. And so I think that the Secretary holds the keys to the prison that Mr. Sims imagines. But a larger issue here is that TARP does not mandate action when the recommendations abstractly possess the qualities of necessity or propriety, but only when the Secretary thinks that they do. Certification requirements are the equivalent of get-out-of-jail-cheap cards. If Congress had the power, of course, to review the Secretary's determination on a non-deferential basis, I'm still not sure that would be a constitutional problem. It would be really messy. It would be even more interesting. But there's no obvious mechanism for formally reviewing the Secretary's determination. And there's no means of doing so without the significant deference that is associated with administrative decision-making. There are all kinds of interesting certification requirements out there, by the way. Reportedly, Tim Geithner is right now sitting on a currency report that says China is manipulating its currency. And once that report is released, he's going to have to engage with some relevant Senate committees and say lots of bad things about China that he doesn't want to do. Okay, certainly you can imagine this kind of this is irrelevant to the president's foreign policy-making powers, but there seem to be ways around this. The Secretary of State must certify that certain countries are compliant with our drug eradication efforts. And every year it's kind of an interesting question. Do we want to insult this country and lose their help, or do we fudge a little bit? I will agree, the TARP IG is stronger stuff. But it does seem as if the executive has some tools with which to avoid significant infringement on his prerogatives. Now, Sims recognizes that there are less invasive readings of the statute that are plausible. And he points, and Professor Siegel focused some attention on this, on the possibility of all kinds of hearings, and you can just imagine the Secretary being dragged up to Congress even more often than happening now to assist Congress with certain inquiries. And it's interesting that we're having this discussion the week that Clarence Thomas and Anita Hill are back in the news. Most of you, pains me to say, were children when I was in law school watching the Clarence Thomas hearings, which were described as a 3-day commercial for term limits. Nobody wants to see Congress having 2 more hearings, but that's politics. Of course, Congress wants to make life difficult for presidents who spend money unwisely. That's the system working. That's not the system failing. It's the epitome of checks and balances, which might be a more useful term, something, the separation of power, because it's very difficult to find true separations of power much of the time. I also want to give a little context here. First of all, the cases that underlie some of Mr. Sims' observations, and then the facts behind TARP itself. So if you look at the Morrison case, it's, I think, impossible to understand that case without thinking about not one but two elephants in the room. First was Watergate, that gave rise to the Independent Counsel statute. And then Iran-Contra, which preceded Morrison by just a couple of years, even though it continued long after, thanks to Lawrence Walsh. Watergate fundamentally weakened the presidency and the supposed purity of a separation of powers law. Because Nixon fired the special prosecutor investigating him. And as fate would have it, the hatchet man was Robert Bork, who at the time of Morrison was also in the news because just 6 months earlier, the Senate had rejected his nomination for the Supreme Court. Not only did Iran-Contra kind of look like a cheap remake of Watergate starring Oliver North and the improbably named Fawn Hall, but the underlying controversy was itself a proxy war between Congress and the executive. With all this in the air, it's not surprising that the case for an unfettered executive did not carry the day, which 7-1, the one with Scalia, lavishly quoted in Mr. Sims' piece, and of course I love Nino, but he didn't make it that time. I also think about Boucher and the Chadha case. I agree these are cases of congressional encroachment, particularly in my view Chadha, but they're not simply about usurpation. I like to think of them as cases in which Congress is really shirking its own responsibilities rather than simply appropriating the executives. In Chadha, the issue is bicameralism, and a one-house legislative veto removes from Congress the often messy burden of negotiating bicamerally and then working on a three-quarter deal with the president. That's pretty bad, but Boucher's actually much worse. Under Boucher, Congress gets to vote for all the crowd-pleasing spending it likes, then wait for some bureaucrat no one outside of Washington has heard of. Does anyone here know who the current comptroller of the currency is? John Walsh. He's acting comptroller right now. He gets to make the tough decisions, and then the president takes the blame for cutting, I'll bet, necessary and appropriate spending that Congress can then complain about. So, yeah, the mechanism was one of usurpation, but I think the real evil at issue in Boucher. Professor Siegel described it as adding to Congress's powers. I'm not disagreeing with that, but I also think they're kind of shirking Congress's responsibilities. The last thing I want to say is sort of the kind of political texture of TARP itself. And I would recommend, if you haven't, look at this book by Andrew Sorkin, called Too Big to Fail. You won't learn a lot of new information if you study the financial crisis obsessively, for example, but it really does give the color and texture. And what comes through really well in that book is the utterly ad hoc, seat of their pants, seems like a good year at the time quality of Treasury's response to the crisis. The indelible images for me are of Tim Geithner padding around the New York Federal Reserve at 3 in the morning in his pajamas, sleeping on a cot as he's trying to figure out what to do, calling up bank presidents on his cell phone. Doing the same thing at Treasury a few months later, when he had no confirmed staff to get anything done. Or Hank Paulson marching up to Capitol Hill to politely ask Nancy Pelosi for $700 billion, which was initially $500 billion, then briefly $1 trillion, but finally $700 billion, because their staff thought that seemed like it might be enough, but wouldn't scare anybody away. There's also the idea of Charles Schumer blanching when Paulson says that ATMs will be shut down within days if Congress doesn't approve this money. And the best part of all is that Treasury never used TARP for what it said it was going to. It was going to buy up the mortgages, the untroubled assets. Instead, it ended up doing exactly what they said they were not going to do, which was to essentially take stakes in banks and make direct injections. I'm not blaming them. It's a tough job. I'm glad I didn't have that job. Maybe because of them, I still have a job. But when you look at this context, it's very understandable why Congress would want some fairly aggressive oversight. One last point about Mr. Sims suggested remedy, returning things to the people. I think this could be problematic in a couple ways. I think I know what the people think about bailouts and TARP, and they're not thinking, I sure wish there was less oversight of these. Just let them spend the money and worry about it later. And yet, he is onto something. It's a problem that's kind of runs throughout, I think, what motivated him to write this paper, and I think it could use more focused attention. It always seems there's a good reason to bend the rules. Right? In Boucher, everybody wants, kind of, to deal with the budget deficit. In Morrison, people believe that no one should be above the law. In TARP, no one thinks that you can spend that much money so quickly with so few controls. All right. The often inelegant constitutional clockwork that Mr. Sims examines is usually threatened precisely when there appears to be an emergent situation that requires thinking slightly outside the constitutional box. So whether your pet issue is healthcare reform, or Guantanamo detainees, or government voters, the public has definitely been desensitized to the need to restrain the different branches of government from reallocating power among themselves in ways that ultimately enhance government prerogatives rather than individual liberty. I don't think Mr. Sims has quite made the case that TARP merits the clarion call just yet, but I suspect this is a subject that will prove receptive to his concerns should he continue to develop them. Thank you.
So my task is easy. First, I want to observe that I knew that I had some sort of bulk in my milk with skills, but I thought it was because we both like to drive fast cars. I also wanted to say, I never thought I would say this, but wow, separation of powers is really fascinating. So I just want you to join me in congratulating Aaron and congratulating Micah, and especially congratulating their families on what an amazing job they've done. Thank you.